Good afternoon. I'm your host, Brian Buckmeyer, here at the Law&Crime Trial Network. So there are some of the arguments. It's a little bit hard to hear some of the defense attorneys' arguments because of the mic situation, but we've got the play-by-play for you here. I'm joined, of course, by good friend and legal analyst, Michael Troiano. Michael, how are you doing today?
I'm doing excellent. Thanks for having me on the show today.
Always a pleasure. Now, Michael, during the break, we were talking about this. We were kind of intrigued about it because at least I think for both of us, this specifically is something that we've never really seen. We've kind of seen it on the prosecution's end where they're like saying, hey, we don't want to turn this information over. And we obviously get out as a defense attorney and say, hey, you can't bombard us with stuff at trial. You got to give it to us. But here we're hearing the inverse, and we know there are different standards for prosecutors and defense attorneys. But the defense attorney is saying, hey, we've got a slew of mental health experts coming in to see our client, Nikolas Cruz. And until we decide to use them or whatever it may be, we don't want the prosecution knowing their names because it could give away our defense. Now, the first thing I'm thinking of, Michael, is, well, they don't know the contents of the conversation. They just know the names of the people. So at best, you can look up who they are and what their qualifications are and what their CV or resume may be. But I think it's pretty obvious who the mental health experts are going to see them and what their backgrounds are. So is this just a whole lot of nothing, or is there something to be made here? Like, what's up?
I mean, I could see it in a different context being an effective argument, and if I was presiding as the judge, I may rule for the defense. But I do agree with you in this specific case. It seems fairly obvious that the reason for these experts and what specifically they're coming in to analyze him for. But again, we're not the defense attorney, so they may have some ingenious idea of what they're bringing forward that you and I just can't quite think of at this time.
Yeah, and I think that's also a good argument. Just because we might be able to foresee or maybe not foresee what the arguments are, it doesn't mean that the defense has to give that away to the prosecution. I know we were talking during the break, and I know in every state it has different names. In New York, there is what's called Rosario as to discovery that has to be given by the prosecution, and Damon as for what the defense has to give to the prosecution. Now, please, Michael, tell me what it is in your state, but in New York, as a defense attorney, I don't have to turn over anything up until the time that I intend to use it. And so I don't have to give them information. Well, the prosecution, they have to give me everything so I can make the best defense. Do you think that kind of argument might come into play here?
But potentially. I mean, here in Nevada, we have reciprocal discovery rules, and there are different standards for the defense. You are correct. We don't have to really solicit or provide information unless we intend to introduce it at trial. And there's certain dates and timelines for witness. It's usually 5 judicial days out. For expert witnesses, it's 21 days plus their CV and any information that they use to gather those expert opinions. So we're going to really see what the prosecution is going to have as far as their counter argument, because in my opinion, if the only thing that they're going to say is, well, we deserve it just because it's a public record, I'm not necessarily sure that's going to fly with this judge.
Yeah, I would agree. There would have to be a stronger argument. And again, not knowing all of the facts in front of us, because we can only report to what we see in court. We can't dig through their files on either side. I think there's going to take a creative argument on either side. Maybe the defense, maybe the judge, sits on the fence and says, you know what? Kind of pointless, like let them have it, or it's kind of pointless, let them not have it. It's going to be interesting to see. We have another hearing coming up later today with Nikolas Cruz. I think it's going to be a lot more impactful than maybe this one. Not that some parts are less than others, but it's going to be interesting to see how this plays out as they kind of carve through the case. So, Michael, I'm hearing a lot of the arguments that you've already kind of alluded to and kind of expanded on as well. What are you hearing from what the defense attorney said that may or may not carry the day for them?
What we just spoke about previously. He's trying to parse out what I think is the obvious here. The state is trying to lay their argument on the judge in a very simple fashion. It's public policy. It's a public document. Anybody has access to it. It's an open government, open file. We deserve it, and let's not fall down that line of Your Honor deciding what is and is not shareable, if you will, and that they should have that information provided. Where the defense, I think, has a more nuanced argument, and honestly, it makes sense. Yes, technically that is a public document, but in this specific set of circumstances, I think due process is going to be what rules the day here, because we all have a right to a fair trial, and providing these visitation logs to the prosecution is going to substantially hurt this individual's case, and as a defendant, your due process rights should be above the public seeing the log of who visits you in jail. It just really doesn't make any sense.
Yeah, so let me see if I can boil it down, and then please stop me from putting any words in your mouth. It seems that what you're saying would be a battle between constitutional rights of the defendant and public policy, and I think we would all agree that the Constitution being the superior document in this country, that was what needs to win the day. So while it might seem like competing interests or competing slippery slopes, I think, at least me personally, I think a judge will agree, and most lawyers would, the Constitution and the rights thereunder as it applies to us as citizens, defendants, whoever you may be, should always come before public policy. Is that kind of a thrust of what you are hearing here?
It was a very succinct and articulate way of explaining my long-winded answer. Absolutely. I wholeheartedly agree.
Yeah, so I think it's be interesting. I mean, and those are the arguments that we make every day, and I think what judges, I mean, some of them go home with the Constitution in their back pocket or cuddle up with it at night. I think the second that you bring up the Constitution, everyone's going to be like, hey, no, we got to protect it. Public policy, we'll let that slide a little today, but you got to hold the Constitution strong. Thank you very much. We're going to continue more looking at some of the other cases we're following. We're going to jump away from Nikolas Cruz, but don't forget, 1:30 today, we've got the hearing, January 27th of 2020. I know it sounds like a far off time. That's when the trial is going to be. But we're going to come back to look at some of the hearing. But first, we're going to take a Kellen Winslow II and see what's going to happen on Monday for that trial.